Okay, I think we are live. Hey, everyone, office hours, June 30th, 2026. Uh, this Saturday is the 4th of July, the big 250th, so that's a lot of fun. Hope everyone has some fun things planned. Stay safe, of course. It's always so funny with my camera. I never know if it's going to be super close up like this or if it's going to be um, backed off a bit, or maybe it'll work. Maybe it'll work differently, or maybe it'll look differently to y'all than it's looking on my screen right now. One never knows. Yeah, I always feel like I don't need my face to be this huge. Back up like this. Maybe that's better. I don't know. All right. So today, what I wanted to talk about was, what is this an indicator of? Oh, I like that better. All right, that's pretty good. Yeah, weird. So today, what I wanted to talk about was buyer rep agreements because we have some new ones from Texas Realtors. So let me just share my screen, and we could talk through some of the key components of the buyer rep agreement. What I don't have is a red line of those. That would have been me a little more prepared, I assume. But yeah, let me. No, doing this live. Actually, you know what I can do? Put this on a different window and then share that. How's that for being smart? Yeah, we're sharing this window now. All right. Okay, so I want to go over, there's four documents I want to go over. TXR 1501 is the long form buyer tenant rep agreement. TXR 1502 is the commercial buyer tenant rep agreement. I don't know how much I want to get into that because I think I'd like to have a different live session just on the commercial agreements. So maybe let's look at that another day. All right, so we have the long form, then we have the buyer tenant rep agreement, which is a short form. I will say the short form, when they made it, it was one page, I believe, and now it's 2 pages. So I know they hated to make it longer. Well, this probably was all 2 pages to start with. Maybe it was the listing agreement. The showing agreement? This is probably it. But at any rate, yeah, I know they want to keep those short forms as short as possible. Yeah, then we have TXR 1508, which is the unrepresented customer showing form. So yes, those are all important things to go over in the world of buyer and tenant representation. So let's start with, I'd like to start with the short form first. Let's go short, long, and then, changing my mind again. Professor's prerogative. All right, we are going to start with the unrepresented customer showing form. So this came around because of a change in legislation, which said that while showing a property is an act of brokerage, that's been true for a while, it carved out an exception to allow agents to show residential properties without a representation agreement, because we can no longer rely on sub-agency, right? So we have this little carve out for showing. So this is the unrepresented customer showing form. Remember, if we represent someone, they're a client. If we don't, they are a customer. So, we have this note here to start with. First of all, property. So this is specific to one particular property, right? This is not saying market location. This is not saying all of Texas. This is saying specific property, street address, and city. So we have this note: unless the broker represents the seller, state law requires the broker to enter into a written agreement with the prospective buyer before showing residential real property. Let's parse that for a minute. If you are the listing agent, if you are the broker or agent representing the seller, you can show your property to unrepresented buyers, rather. That is part of what you are able to do as the listing agent, right? You have to represent someone, or you have to have one of these forms signed. But you can absolutely, as a listing agent, show your seller client's property to unrepresented prospective buyers. All right. Now I've talked to some brokerages who are very wary about this, and they say, "No, we won't. We won't show them. We'll set up an open house, or we'll require that they come back with an agent or something." Every brokerage is free to do what it thinks is in its best interest, right? As far as risk mitigation, as far as anything else. But I will say, remember, you are allowed to do this. That's why this form is here. So this says that the broker will, at broker's reasonable discretion, provide customer with access to the residential real property described above according to the following. So no representation. We're saying, unrepresented customer, you are not a client. Broker does not represent customer as customer's real estate agent. It's just saying that out loud. We know we try to be helpful as agents, and sometimes people who are not our clients can misunderstand us and think that we do represent them. So this is saying this is there's no representation here. Also, no compensation. Broker will not charge customer any fee for showing property under this agreement. If you want to charge someone for showing them properties, you need to get them signed up as a client. There we have it. No advice or opinions. Remember, advice and opinions are reserved for clients, not customers. Broker will not provide customer with any advice or opinions regarding real property or real estate transactions. However, broker may confirm property details such as size, price, or other terms concerning the property. All right, so again, this is confirming details, size, price. These are things that an unlicensed assistant could do, incidentally. So yeah, if you're not representing someone, you can also do that as well. No other brokerage services. Broker will not provide customer with any other brokerage services under this agreement other than providing access to the property. That's all you're agreeing to do here, is provide access to the property. This agreement is non-exclusive and automatically terminates at the conclusion of showing the property described above, and in no event later than 14 calendar days from the last date initialed below. So you can sign this and then go out and see a property. And in fact, what you could do is client wants to see, not client, they're not a client, a customer, unrepresented customer, wants to see 5 properties. You can have them sign the unrepresented customer showing form, 1 per property, and then go out and see it. And this could happen right away. This could happen over a couple of weeks, but you has to happen within 14 days. And as soon as you have shown them 1 property, the unrepresented customer showing agreement for that property terminates. Can't show it to them again without a new agreement. Or if they want to see it again, start talking details, start requesting advice and opinions, right? That's the perfect opportunity to get them under a buyer rep agreement. So we'll talk about that here in a minute. Then we have in bold, neither broker nor any other broker or their associates is responsible or liable for any person's personal injury or for loss or damage to any person's property that is not caused by the broker. Customer will hold broker and any other broker and their associates harmless from any such injuries or losses. Customer will indemnify broker against any claims for injury or damage the customer may cause to others or their property. It's just your get out of court free card. Of course, it's never free. You'd still have to deal with court, but still. Then, by initialing below, broker and customer acknowledge and agree to the above. So we have to have the broker and the firm's name. If there's a broker associate involved, then broker or broker associate's initials. We have the customer's names, their initials, their date. And they want us to check a box here. Customer currently has a representation agreement with another broker. If they do not check this is something you should ask them right away. Hey, can you show me this property? Do you have a representation agreement with another broker? Oh, no. Now that sort of verbal exchange should come down to a he said, she said, right? Or 1 said, 2 said, whatever we want to call it. But if they are here specifically not checking this box, when the thing says to check their box, leaving this box unchecked confirms you do not have a representation agreement with another broker. That is them explicitly putting in writing that they don't have another representation agreement out there with another broker. So that is something you can point to later if there's a procuring cause dispute. Say, hey, they said they didn't have this. Then we have this reminder at the bottom: broker compensation or the sharing of compensation between brokers is not set by law nor fixed, controlled, recommended, or suggested by the Association of Realtors, MLS, or any listing service. Broker compensation is fully negotiable. Brokers independently determine their fees. This is something we talked about in I'm teaching a law of agency class online right now. So this is something we talked about, which was we need to make sure students understand so that they can make sure the public understands, right? That broker compensation is determined by negotiation. Yeah, it's not set by anything. So, and I remember 2 years ago when the NAR settlement went through, regarding taking commission rates off the MLS. And I remember reading one news story that said, we've contacted the Texas Real Estate Commission to ask them what the new recommended brokerage fee is now that this lawsuit is settled, and we'll let you know when we hear back from them. And I just think, oh goodness, we as an industry and we as professionals within that industry have done a bad job of educating members of the public as to how this whole system works, right? So, yeah, we obviously need to get better at that. Okay, so that is the unrepresented customer agreement, TXR 1508. Now let's go to the short form. You've shown someone a house as an unrepresented customer, and they say, I want to go back, or I want to make an offer, or I need some advice or opinions on this. Great, we need to get you under a representation agreement. Now, of course, if you're a sales agent, it is up to your broker, well, A, what form they use, and B, if they're using TXR forms, if they want to use the short form or long form. But let's look over the short form real quick. This says, we just list out the clients there, and we list who the broker is. Remember, listing and buyer-tenant rep agreements are always taken in the name of the broker. It says client appoints broker as client's real estate agent, subject to the terms of this agreement. Now we have to define what the market area is, the area in the state of Texas specified below. You cannot leave it blank. Also, what I would say is, I'm just tripping over myself, do not say the entire state of Texas. Remember, license holders have a legal duty to operate within their geographic competency. If you are watching this and you are competent to conduct real estate transactions in every municipality in every county in the state of Texas, please get in touch with me. I want to talk to you. I want to learn from you. All right. You should be hosting this. So my guess is none of us are. No one is. So you need to, and it gives you some ideas here. A property address. If they just want to talk about one house, great. Put that house in. A subdivision, a city, a county, a zip code, some geographic description, right? Could be the DFW metro area, but I don't think that's, I personally don't think that's specific enough. I would put in counties. That's, at a minimum, right? Or cities. Yeah, just depends. Depends on what you need to work out with your customer, right? Begins on a particular date and ends on 11:59 p.m. on a particular date. So you have a legal requirement as a license holder to put a definite termination date into this agreement, right? And that's what this is here to try and get you to do. If you don't, you're violating the License Act. You could get your license suspended or revoked. You don't want to do that. All right. This states the broker must comply with minimum duties as required by law. Also states brokers may represent other prospective buyers or tenants who may seek to acquire the same properties as the client. So this also determines whether this is going to be a full service representation agreement, where the broker will use broker's best efforts to assist client in the acquisition of property in the market area, or whether this is simply a showing services agreement, where these client obligations, broker compensation, and intermediary issues don't exist, and essentially broker will provide client with access to properties in the market area, and client will pay broker a fee of X amount of dollars. I haven't spoken with anyone who specifically used this as a showing services agreement. What I would be cautious of is if I were signing this with someone and they said, hey, I want to pay you $500 to show me a couple of properties this weekend. Great. In that case, I would want to be very specific, because if I set, if it's all in the same subdivision or city, and I write that in, and it's for the weekend, so I said it expires on a Sunday night, right? And I've got my $500 there. The more I define it, the more I'm understanding my scope of work. But if I say the counties of Denton, Collin, Tarrant, and Dallas, and I said it's a 2-week term, and I say that I'll show them, essentially I'm agreeing to show them any property in there that they want to see, within those 2 weeks, they could definitely run me ragged for that $500. So that's a situation where if you're using this as a showing agreement, I would definitely encourage you to be as specific as possible so that you are, you know, protecting your time. You hate to run yourself ragged for 2 weeks for $500. But if this is a full service agreement, then we get into client obligations. Client must work exclusively through broker in acquiring property in the market area, at least during the time period that the agreement is active, and inform other brokers, sales agents, sellers, and landlords that broker exclusively represents client for the purpose of acquiring property in the market area, or for all such persons to broker. This gives a positive obligation to the client that they have to identify you as their broker in the market area. Attendance at open houses or property showings where no advice, opinions, negotiations, or substantive broker services are provided does not violate these obligations. If attending such events without broker, client will inform other brokers, sales agents, sellers, and landlords that client has a representation agreement with broker. Broker compensation. Compensation paid to brokers or the sharing of compensation between brokers is not set by law, as we've discussed. Each broker independently determines their fees. The total compensation broker receives for brokerage services provided under this agreement from any and all sources may not exceed the amount stated in this agreement. So you could negotiate, let's say, a flat fee of, let's say it's $1,000 for your services under this agreement. If you then get to a situation where a seller says, hey, I'm fully willing to provide, pay the broker's agent's compensation, or the buyer's agent's compensation rather, and I'll pay up to $5,000. Well, you cannot take their $5,000 unless you renegotiate your agreement with your buyer client. If you have negotiated that they'll pay you $1,000 and someone else is offering to pay your fee, that fee is $1,000. All right. So take that with whatever dollar amount, with whatever percentage you want to take that with, but you would need to renegotiate your deal. Earned and payable. Let's go back to this. Broker's fees are earned when client enters into a contract to acquire property in the market area during the term. So again, a contract is fully executed in that case. That's when it's earned. Broker's fees are payable either during the term or after it ends, on the earlier of the closing of the transaction or client's breach of a contract to acquire a property in the market area. All right, so it's payable again on closing or if the client breaches the agreement. So if your client backs out, but you'd previously earned the agreement, then you have your fees are now payable. Source of compensation: client may seek to obtain payment of the broker's fees specified in paragraph 7A from the seller or landlord. Broker will assist client in negotiating any contribution from the seller and landlord. However, client remains responsible for payment of the compensation due broker under this agreement, less any amounts contributed, if any, by the seller or landlord. And look, when my wife and I bought our first house, this is before I had a real estate license, this is basically how our agent explained it to us. She said, look, you are agreeing by signing this that I'm providing you with a valuable service that is worth something to you. And I hope you agree that it is. I will try to get compensation from the seller, but if I can't, you are saying that my service is valuable to you and that you are willing to pay for it, right? We're like, yeah, makes sense. Client authorize, this talks about escrow authorization, which is fine. Then we get into an intermediary situation. So if you think there's even a slight possibility that intermediary could come into play, then I'd say go ahead and check client does. Explain it to the client, obviously, but then the client does authorize broker, essentially. But if it's a situation where, hey, I only represent buyers, I never represent sellers, all my seller business gets referred out, just say, look, it's never going to happen. Let's just check this. Does not authorize broker, right? Then we have a limitation of liability. Then everyone signs, puts their information and signs. And again, this is the broker's printed name. This could either be the broker's signature or the associate of the broker, whether that is a broker associate or whether that is a sales agent. All right, so hopefully that makes sense. Again, this is just a 2-pager. This is pretty easy. I don't know how many of you out there have been using the short form. I think the idea behind having a shorter form is that it's easier to walk through, especially with a uh, potential buyer client who may be reluctant to sign an agreement. In that case, a shorter agreement might be more palatable to them than a longer agreement. All right, now let's look at the long form agreement. This is TXR 1501. And again, this has been updated as well as of June 15th. Oh, I didn't mention this on the short form, but spots at the bottom of every page for everyone to initial. All right. So same. A lot of this is the same information. It's just longer. So we have longer space for the client and the broker to give all their contact info, right? Um, now we're defining some of these things like acquire, closing, market area. Same thing with the short form. You want to define what this market area is. Now, one thing, we also have the term. You have to just have a definite termination date. That's very normal. Um, One thing to note, though, is that there's no option in the long form for it just to be a showing agreement. So if you're doing a long form, you're not going to have a showing agreement that's a long form agreement. If it's a showing agreement, use the short form. So if you're using the long form, you're automatically going to be providing full services to the client. All right, so the client's obligations are the same. Broker compensation information is the same. Now, in this long form agreement, we also have the opportunity for a retainer. That is, that you could have a situation where the client is paying a non-refundable retainer to the broker. And then we also state whether this will be applied towards any other fees owed to the broker under paragraph 7A. We talk again about sources of compensation. What earned and payable means. So this is just a longer definition of what earned and payable means. And then any additional compensation. So if you anticipate that there's going to be additional sources from compensation, you're going to want to use the longer form agreement because that's where it gets into that. So if the property's being newly constructed, for example, right? If service providers are involved, if there's other compensation anticipated. We also give a protection period under the long form agreement. The protection period is the period of time in which, essentially, if you show someone a property and they don't buy it during the term of your agreement, but they later buy it, having a protection period in the representation agreement would give you the ability to say, "Hey, I'm owed a fee for this. If I'm the person that introduced you to this property that you later buy, even if it's after our agreement ends." But you have to determine what that period of time is going to be. I suspect that's going to vary from brokerage to brokerage. I don't have a lot of data as far as what various brokerages use. What I would say is you're definitely going to want to, or at least what I would do, is I would consider what a reasonable person would consider under this. Because, for example, let's say you have to sue under this and it goes to trial, all right? If I put 100,000 days, right? How many years is that? 300? That sound right? Roughly? Yeah. That's a lot of days. I don't think any court would consider that that's a reasonable protection period, right? Essentially, until this person and their great great grandchildren are no longer with us, not a reasonable protection period. If I put 100 days, 150, maybe that's reasonable, because what are the odds that someone's going to see a property during the term of my agreement and then wait 4 months, 3 months or 4 months to then act on it? Unlikely. The odds are, if they see it and they're going to want to buy it, it's going to be shortly after our agreement ends. Simply because, what are the odds the property is going to still be on the market at that point, right? So it could be 30 days, 60 days. I mean, it's going to be whatever you negotiate it to be, right? But I would also think about, if this were going to a trial, whoever the deciders are, what is that going to look like? All right, let's see. And then we have this carve out here. If after this, It's essentially during the protection period, the person gets a representation agreement with another um, broker who is a member of Texas Realtors. This gets down to the fact that procuring cause disputes are handled through Texas Realtors as opposed to through the court system, between realtors at least. Then we have an addition here of county information. Amounts payable to broker are to be paid in cash in X county. I'd say whatever county the broker is based in, that's where they want to be paid, right? All right, we have some representations here that weren't present in the short form agreement, but I would again say that even if they're not explicitly present, they're implicitly present. So, for example, representation A, each person signing this agreement represents the person has the legal capacity and authority to bind the respective party to this agreement. I think anytime you sign a legally binding agreement, you are saying that you have the legal capacity and authority to sign it. B, client represents the client is not now a party to another buyer or tenant rep agreement. In the short form agreement, that is simply, there's a check mark to indicate that or not. All right. If there's an employer or relocation company or other entity that provides benefits to client, then that should be listed. If not, you should put NA. Right. Anytime there's a blank, you don't want to leave it. You don't want to leave it blank. Now, county, it should always be a county in Texas. You don't want to make that NA because that's telling them where to pay you. We also state, incidentally, and I was getting into this with my law of agency students, broker is not authorized to execute any document in the name of or on behalf of client concerning the property. So the deal there is when we are representing clients, we are doing so in a special capacity. We don't execute documents on our client's behalf. We can negotiate deals, but it's up to them to execute. Right? So clients just need to know that from the jump. We're getting to a little more detailed between intermediary, yes to intermediary or no to intermediary, right? But it gets into more detail for sure. Which makes me wonder, is the language in the short form agreement sufficient? I mean, and if so, how much longer does it need to be in the long form agreement? We don't know. Again, a statement that a broker may represent other prospective buyers and tenants. It goes into more detail about confidential information. Now, it's worth noting, even if that's not explicitly stated in the short form agreement, we do still have a legal obligation to confidentiality towards our clients. It's just not listed out for the client to read. So you can state that, but it just wouldn't be listed out explicitly in the agreement. But you're still legally bound, right? This has a mediation provision, which the other one doesn't. I guess the idea is that if it's a short form agreement, specifically maybe even a showing agreement, the odds are pretty low that we'd have to mediate that. What default means, provision regarding attorney's fees, limitation of liability is still there, which is good, and any more addenda that might be attached to the agreement. We have some any special provisions, NA if none. I like this statement about what broker is not: property inspector, pest inspector, so on and so forth. So that's always great. And frankly, even if the broker is those things, in any given transaction, you are only ever one thing. So if you're a broker and an appraiser, you're not going to be both of those in the same transaction. All right. This has some additional fair housing law. Again, we're bound by fair housing laws. We're bound by the NAR Code of Ethics as realtors, but that's not specifically stated in the short form agreement. But you're still legally bound by that, and probably should let the client know. We have other things. If client purchases the property, they should have an abstract covering the property examined by an attorney of client selection, or client should be furnished with or obtain a title policy. That's a legally required notice. It is also in the 1-to-4 family contract, incidentally, so it would show up there as well, because we noted it's also not in the short form agreement. Client may purchase a residential service contract. Good. This is, I think, very important. When viewing a property, client might be recorded or otherwise monitored without client's knowledge or consent, right? So always, and consult an attorney before recording or photographing a property without owner's knowledge or consent. There we have a wire fraud warning, and we have talks about some, oh yes, this language about people who aren't legally permitted to buy certain property. So yes, and consult an attorney. So then we have our spots for signatures down here. Okay, so the 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 fundamentals are the same. I'm not going to say the content is the same, but the fundamentals. I'm going to stop sharing here. All right. The fundamentals between the short term and the long form are definitely the same, and we still have our same legal obligations. But we definitely want to consider uh, when we use the short or long form. It's just going to depend on the situation, right? Now, if it's purely for a showing agreement, you absolutely want to use the short form. But there could be situations where someone is really reluctant to sign a longer form, even if a lot of it's boilerplate, even a lot of it is restating our legal obligations. You still have clients that might not be comfortable with that. So it could be a situation where the short form is going to be the only way for them to sign a representation agreement. So you take that. This is something I think brokers absolutely need to do. So if you're a broker, hopefully you are training your agents on, having a script as far as sitting when it's appropriate to use what form, and how you sit down and present this to prospective buyer or tenant clients. I hope this was all helpful. I'll try and generate some additional resources based on this once the video drops. So head on over to edu.realestate to check that out. And in general, next week I want to talk about listing agreements, and after that, I think I might do a little bit of discussion about these types of agreements in a commercial setting, because that's where I have a lot of experience. All right. Thanks for joining me. Thanks for watching through. And I will see you next week. Or remember, if you subscribe to the Substack, even for free, you get free stuff. You get notifications when Substack Lives are coming, that whole thing. So talk to you later.